So in today's episode, we will talk about femicide.
Femicide is really not provided for in law, specifically as an offense.
Are questions like what happens to the perpetrators of this crime? How does the justice system deal with Welcome to the Sisters in Law podcast. My name is Beverly Mokaya and I'm here with
Aquila Mokaya. In this podcast, we'll be discussing matters law.
From navigating financial and business law to talking about tax laws and explaining to you how contracts work, to breaking down legal complexities in litigation, family law, employment and labor relations, we got you covered.
Remember to like, share, subscribe, and hit the notification bell.
So in today's episode, we will talk about femicide. Femicide cases in Kenya have been on the rise in the recent past, and maybe the questions that you guys are asking are questions like what happens to the perpetrators of this crime? How does the justice system deal with such people and such suspects? So yeah. Mm-hmm.
Actually, I think it's very important to start from the definition of what femicide is about and whether it's governed in law. It's provided for in law, specifically like the penal code, which lists all offenses and all charges.
Mm-hmm.
So for femicide is really not provided for in law, specifically as an offense.
Mm-hmm.
It's really just the murder of women on the basis of their gender.
Mm-hmm.
Yeah.
So, like in Kenya, there's this statute called the Penal Code. It's the one that you talked about, the one that mentions every crime in Kenya. It specifies the crime of murder, manslaughter, rape, anything that you can think about is listed in that act.
Mm-hmm.
But there's no specific crime called femicide.
Yeah.
So now, like if a prosecutor is just like when the state is taking you to court, that's they come through prosecutors,
Mm-hmm.
through the office of the DPP, that is the director of public prosecution, and so the charges that they would bring against you in such an instance would be, like you said,
Murder and manslaughter,
mm-hmm.
and or depending on, because also for murder they have to confirm, or the prerequisites for murder in itself are actus reus and mens rea, that
Mm-hmm.
is the action in itself, which is killing, and
Mm-hmm.
also the mental state, that is the intention to kill.
Yeah, like law has, because we got these things from the colonial masters, they always insisted on us talking about, like, mentioning things in Latin.
Yeah.
So now you'd hear words like actus reus and mens rea, but actus reus just means the action. Now the action of murder, there's the part where someone kills somebody, and then now mens rea is the mental state, because for every crime in this country or anywhere in the world, there has to, like, the prosecution would have to prove beyond reasonable doubt that there was an action. First of all, can you place this person in the scene?
Yeah.
And then that there was a mens rea. Now this is the intention to commit this offense, whereby you have to prove that there is an action, and that there is the mental state that this person actually planned to commit this offense.
Yeah.
Yeah.
Also, if for example you maybe commit assault, for
Mm-hmm.
example,
Mm-hmm.
like you hit somebody and they really don't die immediately,
Mm-hmm.
there's always the charge of manslaughter
Mm-hmm.
upon their death.
Mm-hmm.
That is, we have to wait for a couple of days, like maybe 1,000+1 days,
Mm-hmm.
for to know whether the person is going to die
Mm-hmm.
or they are going to survive.
Mm-hmm.
So at such a point, if there was no intent,
Mm-hmm.
if for example I got angry and fought with anybody and then they died,
Mm-hmm.
it would always fall under manslaughter, because I really did not think in my mind, I didn't have the intention to actually hit them to die.
Yeah.
Yeah.
And actually, you would find that mostly when the prosecution is bringing cases of murder, they always have to accompany it with a charge of manslaughter, because it's very hard to prove the intention, that someone planned to kill, unless you could maybe see that they went and bought an axe somewhere, and like you can place that person in the scene of actually buying an axe, let's say days before. Let's say you can prove that they traveled all the way, and that they had planned to kill this person way before.
Yeah, so like that other case for Republic versus should be Kinuthia or somebody in Eldoret who traveled all the way to Eldoret and asked the girlfriend on the basis of, I think, mistrust and also
rejection.
So for that, there's clear
Oh, and by the
intention.
way, he also refused. The lady also refused to take his financial, you know, yeah, his financial aids. Okay, I don't know how. Okay, you can't say financial aid, but his financial support. Yeah.
Yeah,
So
so
now,
he traveled with an axe and actually killed. So ideally, there was actors rears, which now is
the action.
the action of hitting her to death, to ensuring that she actually died. And there was also the thought because he traveled
all
from
the way
Nairobi and went with an axe. Yeah.
Actually, a machete. Actually, that's already a determined case in Eldoret.
Yeah.
In the High Court of Eldoret. And this person is behind bars right now. He was imprisoned for 30 years.
Yeah, actually, on that note, let's have a conversation on how is murder punished, really?
Yeah, so what is there still in the penal code? Like we said, the penal code prescribes the different offenses that are there, and not just the offenses, but the punishment for it. Yeah, so like it would say, let's say for example, if it's the offense of murder, there is life imprisonment, and so currently this is a lot of legal jargon, so you can't say precedents and stuff. But what happens in Kenya is sometimes the judiciary or the courts can also participate in lawmaking, through deciding cases. So like in this case, the penal code says that the offense of murder is punishable through the death sentence. There's a recent famous case called the Murwatetu case that was decided in the Supreme Court. I think it is in 2020 or something. Yeah, whereby they said that the charge, the sentence of life imprisonment, the mandatory death
nature.
sentence, the mandatory nature of it is unconstitutional. And so nowadays, that's why you find even in this case of the Eldoret case of Kinuthia, this person was sentenced to 30 years. Ideally, they would be sentenced to life imprisonment. So yeah, and actually when the prosecution is prescribing a charge, they usually quote both the section 4, the offense, and the section 4 for the punishment. Yeah, so in this case now, femicide, we're talking about femicide, there's the killing aspect.
And there's also, because it's based on their gender as women, mostly there are reports on sexual offenses that were done before the murder. So, actually, sexual offenses are governed by the Sexual Offences Act. And I think Section 3. Yeah, so like rape in this instance would be for any person who's above the age of consent, which is 18. So if there was penetration without consent, just right before the murder, they could attach the sexual offense of rape. That's if the dead, now the complainant,
the victim.
Yeah. Now that the victim is dead, if the victim is above 18, they could add a charge of rape or maybe attempted rape. Because also for sexual offenses, they put either maybe rape and then attempted, just if they cannot prove the first charge.
And by the way, the office of the DPP, that's the Office of the Director of Public Prosecutions, is all about putting people behind bars. Like they will pin you down with every offense that they can get in this instant. So they don't just have to get you on murder. They would want to get you on murder or manslaughter. So I think that one would be an alternative count in the event that they cannot prove your state of mind. And then they will also attach rape there. If that person was above the age of consent. In Kenya, it's 18. Some jurisdictions have 16. There's the offense of rape, which would apply to the victims who are above the age of consent. But then the alternative of that would be defilement if the person is below 18 years old.
Consent,
yeah, so for rape, that would give you
10 years to life imprisonment if you're found guilty. And of course, our laws provide that as long as it is penetration and there was no consent.
Mm.
And in this instance, if it leads to death, most definitely there was no consent.
Yeah, definitely. And actually, the issue of consent only comes up when someone is above 18. Apparently, the law says that if you're below 18 years, you don't have capacity to consent. Not consent. You can't say that the child consented, that the minor consented to having sex with you.
But also for minors, if they cannot prove defilement, they would always go for indecent touching of the minor, because mostly for minors, okay, for the ones above 18, whether there's consent and there's no consent. So when there's no consent, it's most definitely rape.
Yeah.
Like it would be rape. But when it's for a minor, it's going to be defilement. If they cannot prove the offense of defilement, they go to attempted defilement, and then also now they could charge you for indecent touching.
Yeah, and indecent touching actually touches on a lot of, it's a very wide offense. If someone touches your private parts without you, it's the truth. It's been okay. Do we have to be shy about that? No.
Touching the private part?
Well, it's true. Like actually, if you read the act, it defines indecent touching. So if you, I think maybe okay, so like it defines indecent touching in section 3. So mostly every act is a statute. Like it's just.
What just provides for?
Yeah, it's just like
law
laws
in
in Kenya.
section.
Yeah, different sectors in Kenya are governed by different acts of parliament. So that you would find there's an act for employment. There's an act called Employment Act that talks about laws on employment.
Yeah.
There's an act called, let's say, Traffic Act. So that's what an act means. It's just a statute. Yeah.
Yeah.
So like I was talking about this act, the Sexual Offences Act, which defines indecent touching, and it's a wide one. So that's why, like I said, the office of the DPP always wants to pin you down on every offense. So if they can't get you on rape, they'll get you on indecent touching, yeah, or committing an indecent act with a minor or things like that.
Yeah, also femicide is also governed by international instruments, the ones that Kenya has ratified. So Maputo Protocol is one of them, but they also do not really talk about femicide as a crime. They discuss just the rights of women, the obligation of the state to protect the rights of women. There's the right to life under Article 26, and which is an absolute right without a limitation. Like that's the only right that doesn't have any limitation on it. Yeah. So for all the laws, the international instruments that have been ratified by us, in which we are parties to them, then that most definitely means that our state is obligated to actually protect the rights of women. In this case of femicide, the right to life of women.
Yeah, and actually that also just for your general knowledge, that Kenya we are a sovereign state, but we are part of a region. We are part of a globe. Yeah, So like you would find that sometimes the UN so you'd find that these international groups, would come up with laws or conventions. They call them conventions. They are soft laws. Yeah, that would prescribe what states are supposed to do. And you see that there's this provision in our constitution that allows us that if Kenya has ratifying is just sort of accepting in the layman's language, yeah. So if Kenya has ratified a convention or an international law, then it applies as it is in Kenya.
Yes.
Yeah. So like you see, like whatever you said in the Maputo Protocol obligates governments to come up with laws for women. Yeah.
Protect the women.
They protect women. Go and report. You go and make a complaint at the police station. And then they do their investigations. They arrest the suspects. They do their investigations. Then they arraign this person in court, or they get go ahead from the DPP to charge, or to charge means just to take the person to court. Yeah, and bring these charges against them. And then now the process you will go to court. This person might, like they usually take plea on the first day in court. Yeah.
Is guilty or not guilty.
So taking plea is just, I'm sure people watch the news, so most people would understand that taking plea is just going to court and say, I'm guilty or I'm not guilty. It's very rare to find people saying they're not guilty. No, they're guilty, yeah. So mostly they'll say not guilty, and then.
But that's also, sorry to cut you short, but that's also an aftermath of being read to the judge. The judge must be read to you in a language that you understand first. And if it's a capital offense, like in this case, if it's murder and or
robbery with violence,
manslaughter and whatnot, the plea must be taken in the presence of an advocate. Yeah, because it's a capital offense.
Okay, yeah. So once you take your plea, you have a right to get bond or bail, but mostly it would be put at a very high amount because you know you are, okay, you can say murderers because you know people are innocent before proven guilty, like innocent until proven guilty.
Yes.
So you would definitely need an advocate for this, and everybody has a right to representation. So you would need an advocate for that, and you can get an advocate
from the state in such matters.
Yeah, from this. The reason why you need an advocate is because sometimes actually, and like now, like we said, the law provides for you being innocent until proven guilty. Sometimes unaweza ekelewa tu. It's very I've actually handled cases where mtu aliekelewa tu that they killed someone. Remember that case, by the way,
that boy.
Yes, you remember.
You said the name.
Yeah, you can say, but you remember the case,
yeah.
Yeah, so like this person was literally framed because he
was a chokorant. Oh no.
So like anything can happen. So that's why you need an advocate to help you in such matters.
So ideally, when you are charged with such an offense and you do not have an advocate, you are supposed to get an advocate from the state. That is now the judiciary is supposed to allocate to you an advocate because of the nature of this offense. And also, if it's just children in conflict with the law, generally, you must always be given an advocate by the state.
Yeah, we're talking about you take plea, and then maybe you will apply for bond, and bond is at the discretion of the court. That means the court decides how much to give you. If it's too high, you can always come back and ask for a variation of the bond terms to maybe if you have enough like good reasons, like reasons that are good enough, maybe you're not able to afford it or stuff like that, So in applying for bond, you get the bond, and then you would either handle the case, like participate in your case, whether like while you're still in remand or outside. Yeah, so in this case, we also have judges and magistrates who can handle your case. They would give you bond, and if you get bond, it means you can attend to your case when you're outside, like outside of the prisons. But if you don't get bond, or if the bond you get is not affordable, you'll just have to be in remand as you come and attend your case.
So just a quick question for these capital offenses, do they give cash bail or it's just mostly bond? Because now bond could be either my car, my piece of land, a house, something that is of value, like my own property. In bond, I'm not giving any money to the state. I'm just giving a part of my property. And do you think for these matters they should give cash bail for such matters?
For what I know, based on us treating suspects as innocent until they're proven guilty, the bond terms should be reasonable. You have the right to reasonable bail. So I think that kubagua or discriminating that because this is a capital offense and this is a different offense that you're going to give them different thresholds of bond is actually going against the principle of innocence until proven guilty. Really? Because if you're supposed to treat everyone as innocent until proven guilty, you're supposed to assume that this person did not commit that offense until the justice system proves that they have.
But I want to think that you are always given bond terms and bail terms, bond and or bail that is commensurate to the offense. So whether it's, we are presuming that the accused is not guilty.
Okay, but just for the public interest, balancing.
But it's very important that if you committed an offense that is worth maybe, like murder is a serious offense because it's going against the most absolute right, which is the right to life. So I think that is the highest, quote unquote, highest offense that can be committed. And I think the bond terms, bond and or bail, should be commensurate to that, to the heaviness of that, of the crime. Like an alleged thief, an alleged petty thief, and an alleged murderer, because of the heaviness of the crimes.
Yeah.
So the bond and the bail terms are always commensurate with the heaviness of the crime. That's what I think. So after plea taking now,
Wait, before you even talk about plea taking, I think that makes sense now in the sense that, because what I'm getting is you have to balance the public interest against the interest of the person, against the rights of the person. So that's why the bond terms vary like that. So yeah, that makes sense. So after plea taking, you go back and you start, tending to your case. The case now actually starts. You go for hearing.
Yeah.
So what usually happens is the prosecution will bring its witnesses. I think I already said what the prosecution means, right? It's the state. Like now, whoever is bringing the case against you, which is the state. So the prosecution will bring its witnesses, and they will be heard. Basically, that's the witnesses against the person who has been charged with that offense. Yeah.
So after the prosecution brings their witnesses, there's always cross-examining. That is now like asking questions. So the accused can ask the questions themselves, or their lawyer. It's especially most advised that allow your lawyer to actually ask the questions, because the questions are supposed to like sort of poke holes in the case of the prosecution. So after they bring their witnesses, after they testify, all of them, and they ask the questions, the prosecution now closes its case. So upon the closure, there's always now a ruling that is given on whether you have a case to answer or not. That's if there is a crime, if the prosecution now has proven their case beyond reasonable doubt, which we had actually talked about, on whether there is no doubt that you did and you did. So after that ruling is given, now you are put on your defense as the accused. When there's a case to answer, you bring now your witnesses, and you can also now testify for yourself also. Yeah. And where you'll also be asked questions by the prosecution, and also maybe the advocate who's watching brief for the accused, for the complainant.
And actually, you can either give a statement that is sworn or an unsworn statement, or you could keep quiet. You're allowed. So for a sworn statement, you will be cross-examined, like where you actually took an oath and said, I so and so do swear by the Almighty and stuff. Yeah. So that's what happens. And if you're actually, there's something I wanted to add regarding if this accused person did not have a lawyer when they drink their case, when the prosecution is presenting their case against them, and they get a lawyer after, the lawyer could also ask for recalling of those witnesses so that they can be actually properly cross-examined based on the fact that the accused person doesn't know the processes of the law. And trust me, you need a lawyer for that. So in the event that the accused person is in the event that the magistrate or the judge decides that this accused person has a case to answer, now they can defend their case. So you say, I didn't do this because of this or this. Maybe I had an alibi. An alibi just means I wasn't in that. Let's say I was in Loitoktok, and the offense happened in Nairobi, and I can prove that I was not in Nairobi at that time. I could call my witnesses as an accused person. So after that, now the magistrate or the judge will determine the case based on the evidence that has been provided before them. And then so they can either hold you as convicted or acquitted.
So when you're convicted, you have like 14 days to appeal to higher court. So if it's magistrate court, we have the high court, then the court of appeal, then the Supreme Court. So it depends with where the case was first lodged. So upon conviction, you are always allowed 14 days to appeal. So when you're appealing from the magistrate's court to the high court, they cannot add any other witness. For any appeal, we cannot add any other witness. You put on your defense, ensure that you get all your witnesses at the same time, so that once the case is determined, you do not have to ask for another witness, because it's not allowed after appealing.
And actually, even before appeal, when you're convicted, you're allowed mitigation. There's this thing called mitigation. Kama unajitetea sasa.
Malilio.
That's malilio actually. Malilio just means you know, have mercy on me.
Yeah,
Like I'm remorseful about this.
Yeah.
So I've already been found guilty. So maybe I have a small child somewhere, and maybe I'm a single dad or a single mom, and this
Maybe I'm
person cannot,
sick.
you know, maybe I'm sick, I have this and this terminal disease or something, so that the magistrate or the judge can be lenient with their charge on you. Yeah, so you could either so an appeal can be on the conviction or can be on the sentence or things like that. Yeah, exactly. So when you're going to report, when you're going to report this crime, the police station, because that's where you go first, you have to there has to be a dead body, you know, like because it's a murder.
Really?
You have to show that there is death. If it's a missing person, there's a period for which a missing person can be declared dead. So if you want to report such a crime that has happened, you go to the police station. There has to be a dead body, because because it's a murder, there has to be proof that someone actually died, that the action was done. So your part is just to report. Then the police officers would do the investigations, and then they would bring a charge against the suspect
upon arrest. Yeah.
And then arrest him. And then the process that we told you now you can go back to, plea taking, bond and bail, and the hearing until the end of the matter. Yeah, so I think that's it for today. So that's the end of today's episode. I hope you enjoyed it. I hope you learned. If you have any comment or any question or anything that you'd like to say, you could do that in the comment section, and we'll be sure to include it in our next episode.
Yeah. Remember to like, share, subscribe, and hit the notification bell so that you can be alerted once we post. See you in our next episode. Bye.
Bye.
Ciao. You know, cut.